if you were to estimate forward, it would put him at $143,000, which would be about a 35% pay raise. Nobody at the Border Patrol as a field agent would receive a 35% pay raise.
My client's position is that there's a lot of work at the border. It's a crisis. This is kind of a new territory, a new area. So whether he's actually going to continue to make this overtime is, believable.
I don't even know if I can take judicial notice of what's going on at the border.
But my client would prefer to get this over with today if possible. However, what we did discuss is that I've received the obliger's tax pay stub through the end of June, and he's on track to make $140,000. And so the disagreement is he going to end up making that much money at the end of the year? We don't have any way to compare that because I don't have end of the 6 months for 2022, the pay stub, or end of the 6-month period in 2021 pay stub to see if he was on the same amounts as he is this year, to determine if he's earning a lot more money this year compared to the other years, because that would shut down the obliger's argument that he's fixing to be cut off from making overtime. They have not produced.
So, do we have his paycheck stubs, Mr. Macomb?
Ma'am, we have one that we circulated. The discussion with this was my client's W-2 statements since 2020 altogether reflect a $3,000 difference. If in just looking at this year's pay stub, if you were to estimate forward, it would put him at $143,000, which would be about a 35% pay raise, which nobody at the Border Patrol as a field agent would receive a 35% pay raise. That my client's position is that all of these years with the overtime that he has allotted, they will end up capping it to keep him within that same pay range of a base salary of $102,000 to keep him in accord with an annual cost of living increase. The discussion we had with Mr. Feist and Mr. Harper was simply to go back to get June of 2022, June of 2021, and perhaps June of 2020 to show if in fact you had the same large amounts of overtime that were ultimately capped through a reflection of seeing the W-2 at the end of the year. If so, well, then that would be consistent with our position on where this would be headed by the end of the year, because from what we're seeing, Judge, my client would not be realizing a 35% pay raise by the end of the year. That is inconsistent with any pay range of any Border Patrol agent that I've ever represented. So be it a manager or field agent.
But Your Honor, my client's position is that there's a lot of work at the border. It's a crisis. This is kind of a new territory, a new area. So whether he's actually going to continue to make this overtime is, believable. So all we have pay stub from 2023. However, we would like to get this over with, the sooner the better.
All right, but I only have one paycheck stub.
It goes through the end of June, like the end of the pay period was July 1st of 2023. So we have it all the way through July 1st of 2023. And
yeah, except your year-to-dates don't show the overtime. It doesn't set it out. And so if there was overtime and his paycheck fluctuated.
It does show his overtime through the end of June of 2023. And it shows that he's on track.
But does it break it down? Does it separate the overtime from regular pay is what I'm talking about?
It talks about supplemental pay 25%. It talks about within
I don't know. You go ahead and show it to me, Mr. Harper. Let me tell you why. The family code allows me to order him to bring that. And if I need it, I need it. I know we want to try to go forward today, but let me look at it. I think the issue is, are you saying that the projected income pushing forward, is that what you all are disputing?
Well, I'm sorry, the response to that, yes, that is the issue, is what's going forward. Our position on this is that the increased volume of activity at the border is not unique to 2023. This was occurring in 2022, 2021, but the pay range still remains consistent within 109,000 to 112,000. Our position is that's not going to vary now because there's no real insurgence at the border that hasn't been realized for the last 24 months or 36 months.
Well,
So,
and I
as
think
you-
what I'm thinking to myself, Mr. Harper, is I don't even know if I can take judicial notice of what's going on at the border. Even if I were, how is that going to translate into income amounts?
Well, I would say that through the end of June of 2023, he earned gross income of $71,333.08. So there's 6 more left to go.
All right.
To continue.
Right, but then how am I going to compare that and isolate it to just 2023? If the family code authorizes me to take at least order him to bring his paycheck stubs at least, or income for the past 3 years on an average, I'm not going to have that. How are we going to be? I think what you're going to ask the court, I guess, is to do just like a projected based on the first 6 months.
That's correct. But
yeah, I don't know. Did you all do discovery? I'm noticing in the file, you all asked for a request for production, but, and there were several, items that were left, but that haven't been heard. I don't know. Right.
I know the Attorney
go
General did. So I'm representing the obligee. I'm not sure they produced everything that was requested in the first amended petition that was filed on May 11th of 2023.
And did you request for paycheck stubs?
It asked for
his pay information? Let me look.
It was in the discovery, in the petition, but I didn't personally send any discovery out. But I guess what the argument is that, well, he's making all this money, but he's not going to make over 104,000. Therefore, the remaining 6 months, his income is going to be cut way down. But we don't have any proof of that other than testimony. So
if I can, the comparison, I think, is the ingredient that is missing here. If you were to look at, again, as you had suggested earlier, Mr. Harper, to go back June of 22, June of 21, and then to see where it ended up on the W-2, if in fact he was capped, to keep his pay range as budgeted for the Border Patrol for a field agent. I think that's probably a great idea. And all we're talking about, actually, judges, is a 2-week reset to produce all this, so it's in front of the court, and so we're not estimating a 35% pay raise. I honestly, it would be limited to that as far as testimony, but 2 weeks I don't think is going to go one way or the other, especially when we're considering my client is $11,000 in future pay.
Well, if he's in future pay, then there really is no harm. But remember, on a motion to modify, I can go back retroactively. So to say that I can consider that for the parties, in other words, we can go back. It's been on file since January the 12th, 2023, with the first appearance date being more or less like around, I think maybe February or March. I have to check the file again, but it seems to me, Mr. Harper, what I'm trying to is that you may have that one paycheck stub, but I'm thinking that Mr. Macomb is going to have Mr. Garcia testify, and he's going to be testifying as to things that are obviously that he has some sort of personal knowledge based on the fact that he works or the instructions he's been given. And so I don't know that maybe we do need I think we do need the pay information. Because you're asking me to do it on pure speculation and to get a projected date. I'm thinking.
If the court is inclined to reset it, would The court also ordered the obliger to turn over the tax return and W-2 form for 2021. I already have the ones for 2022. And then the pay stubs through the end of June for 2022 and 2021. Because my concern is we don't have those documents. The obliger is going to be testifying about those years.
Right,
And
right.
Thing.
And that's what I'm trying to avoid, is to have a trial setting and just going by pure speculation plus any testimony he may have without being corroborated by something that he can surely get. And then there's interrogatory requests, but I don't know. I don't think they were done on behalf of the obligor, but we can do informal discovery. But the family code does allow me to order him to bring them, Mr. Maycomb. So, Mr. Garcia, did you file your income tax return for 2021?
Yes, ma'am.
All right. And the one we have is 2022, correct?
That's correct.
All right, then, Mr. Garcia, we need you to provide your income tax return for 2021. And then you provided your last year to date. I mean, your latest paycheck stub. I think you're only showing one, but Mr. Harper, unless I'm mistaken, it does set out the overtime, but it doesn't set out the overtime per pay period. And sometimes that tells us a lot. In other words, you can tell per pay period whether there's even an average, as opposed to just telling me all the overtime he did, because the person could have done his entire overtime in 1 month as opposed to monthly. And I haven't seen it, but does it have it broken down by pay period?
It is, Your Honor, but if the court would be willing to order for every pay period for 2023, every pay stub, then we would be able to see every pay period how much is getting overtime up until the end of June.
So the paycheck stub you have already has it broken down month by month, his overtime?
No, it's just
It's
Uh,
year
It
to
just
date.
gives you, it just gives you the entire amount he's made in 2023.
that's
Correct.
correct.
Okay, yeah, no, Mr. Garcia, we need each and every paycheck. You get paid every 2 weeks?
Yes, ma'am. Biweekly.
All right, so you have about 15 or so paychecks that you've got to produce for the year 2023. They should be readily accessible to you because I think it's direct deposit, or you can have them emailed to you. So we do need that along with your income tax return for the year 2021
And the W-2 form?
and the W-2 form. Now,
Judge,
you also should bring your 2020 so we can get the last 3 years. However, the 2020 is probably going to be something that's unique because that was when the pandemic broke out in March of 2020.
Okay.
So if you can get that one, Mr. Garcia.
May I go over this just to make sure? You're wanting his tax returns 21, 22, pay stubs for January 2023 to present, W-2s for 2020, 2021, and 2022.
And I think she said also tax return for 2020 and W-2 form.
Okay, Judge, is that correct, that the tax return for 2020 as well?
What area, Mr. Garcia, are you do you work? Is it the border along Maverick County?
No, ma'am. I work in El Paso, Texas.
Okay, which is also a border. So yeah, we need all that information.
We'll have that, Judge. I'll have Mr. Garcia collect it and circulate it between Mr. Harper and Mr. Feist. And so we'll be ready by, I'm assuming, August 15th. Was that the reset date?
Yes.
August the 15th is fine if we can do it. This is a Maverick docket anyway, Mr. What I'm thinking is we might have a full docket in the morning. So do you all want to do it at 1 o'clock on August the 15th?
That's fine. Fine with me.
Sure, Judge.
All right, then we'll do it on August the 15th. You use the same Zoom code and the same, everything's the same except the time instead of 8:30 will be 1 o'clock. We'll finish with the morning docket.
Just to be clear, Judge, right? The end of the pay stubs, not the entire pay. Every time you got paid for 2021 and 2022, it's just that one stub ending at the end of June of 2021 and 2022 is what he's going to produce.
No, I think that's what you have now, Mr. Harper. If you get me, and I haven't seen what you have, but most paycheck stubs, when you're looking at a year to date, it doesn't reflect overtime per month, monthly. It just gives you the entire income he has earned year to date. But in this profession, in this occupation, I think what you're telling me is his paycheck stub separates overtime from regular pay. So
Right.
if you look at his paycheck stub for the end of June, for example, it's gonna set out how much he earned year to date. And what you're telling me is it's gonna reflect how much of it was overtime and how much of it was regular pay. But it doesn't tell the court how much overtime he made each month. And the reason it becomes important is because if you all are talking about overtime, it's possible that all his overtime was done in 1 month because of the circumstances. They just asked him to make a bunch of overtime in 1 or 2 months, but it was out of the norm. It wasn't his normal routine, and it was never going to happen again. It was just a coincidence, not a coincidence, but it was just based on the situation. So that's why the court is requiring, at least for 2022 and 2023, the paycheck stubs. I could see 2020 it's going to be too much out of the norm because of the pandemic. And so I don't want just one paycheck unless you're willing to concede, but it's overtime that we're talking about. So
Are we talking about like from 2022, just to show the first half of the year, every pay period for 2022 and 2023? The pay
for
stubs,
sure we need 2023.
right?
Okay,
Okay.
we need each and every paycheck stub. He gets paid twice every 2 weeks. So you're looking at right now, July. So that's like about 14 paycheck stubs. That's not anything that's difficult to produce.
Okay.
2022, same thing.
Okay.
Okay.
So pay stub, Judge, for January 2022 to the present. And then
Correct.
the W-2s and tax returns for 20, 21, and 22.
Right.
Right.
Correct.
Okay. Yes, ma'am. I'll assist Mr. Garcia and get that circulated.
All right. And then we can come on the 15th at 1 o'clock.
Yes, Your Honor.
They reset the thing from the divorce decree. Wasn't the divorce decree, was it March 1st of 2018?
Yes, it was 2018.
That's the new one though, right?
No. The original
the old
divorce decree was the old one, or the first one.
The one that you're talking about is April 4th, 2018. That's the one that reflected $1,000 a month. There was one that was attempted to be entered that was set aside. That was the one that had it at $1,250. That's why we're here at the overpay. So my question is Mr. Feist, is for this period between April and September of this year, how many months was he still paying the $1,250 a month?
You need to share the screen of the financial statement, Mr. Feist. There it is. Oh no, that's 2022. Can you go all the way up to 2018? You're doing splendidly, Mr. Feist.
Yes, this was after they changed everything, Your Honor. So as of March 1st, he was paying $1,000.
So if you see that
This-
prior to that, he didn't have a balance. He had no balance. So March.
Right, and this will show then because of this, he's in future pay of $11,000. That doesn't show on the financial activity report.
At the end of
This shows the change of $1,000 calculated from the 1st of March when it should have been $1,000. Okay, that's why he has $11,000 in future pay.
Okay.
Because he was paying $1,250. Is that correct, Mr. Macomb?
Yes.
And that's why the
doesn't
new
reflect-
financial activity report was corrected from when that divorce decree should have been in there.
So is it
Okay,
fair
so-
to say that if he's in overpay, she owes him, let's just take it simply. She owes him $11,000. Rather than pay him the money for $11,000, we take the amount of, it should have been from that date. No, the motion to modify is going to be granted as of April of 2023.
So if you look at
So
April.
beginning April 2023, his child support should be 1,707. So there's a difference of $707. So if we have him in future pay of $11,000, in other words, she's got to pay him back $11,000. Our begin date is April of 2023.
Your Honor, if I may, there,
Mhm.
Mr. Feist, I know this is reverting all what was actually paid to what it should have been paid, but this doesn't reflect how much between that time period of April and September of this year that he was still paying the $250 over the amount ordered.
Yes.
Your Honor.
This doesn't, this reflects, that's why there's an $11,068 future pay.
Yes, sir. I understand. What I'm saying is he continued to pay that $1,250 for a period of time. This was only corrected a couple months ago.
Oh,
Mr.
okay.
Mr. Garcia, Mr. Garcia, do you remember what month it was corrected to 1,000? I mean, or Mr. Feist, you should show that in your system. I would guess that on what date did it actually correct? And then from there, you'll see how much of the $1,250 he should still get, or the $250 over that he should get credit for during this 6-month time period that we're talking about. If it was only corrected in May or June or July, then that's $250 times 5. So that's $750, $1,000 that he should be given credit for. Calculating.
Wait a minute. It's almost like you have to do the financial statement. Mr. Was it being wage withheld?
Yes.
All right. Well, but the $1,000 you're seeing, Mr. Makem, is amount due, right? You need to be looking at the column that says how much he paid and whether that amount totals 1,200, because it was being wage withheld, so they were taking out 1,200. So that's going to be in the middle column. $1,000 just reflects what he was court ordered to pay.
Yes, ma'am.
And it changed once the correct order was put in.
Your Honor, if I may, the correct order was put in. I'm sorry, Mr. Makem, I was speaking. Your Honor,
This is start right here of 1/1/2023.
That was when it stopped. Yeah. The last
I don't
payment
think
went
that, Mr. Garcia, do you
No, it
recall
hasn't. It hasn't stopped, Your Honor. That's why these are a minus.
No, there's no payments coming in that column from December 2022. Go to the
Yeah.
top.
That's why we have to talk to financial. Your
Yeah,
Honor.
guys, I think we're struggling because nobody can tell. I mean, you can't figure out the amounts until you're looking at when they gave him credit and how much. For example, Mr. Makem is saying they were wage withholding $1,200. Well, we need to see that on here. And first they have to track the order. So if your divorce decree said, we're going to change it to $1,000 effective April of 2018. Well, it looks like they already do that. They already did that. See, they
As of March
amount
2018.
due. Yeah, so they got that part. But then he continued to pay 1,250. I guess we can figure out if 584 total on he gets paid every 15 days. If you multiply, oh no, it changed. 565.89 times, hold on. It was 1,200 even. All right. Yeah, the question is if those payments totaled 1,200, and I'm not getting it to the penny.
Well, you remember this is over 26 pay periods, Your Honor. So
I did that. I did. Let's assume the payment. Let's assume you all got the payment right on the wage withholding. Let's assume the child support was 1,000 per month times 12 months in a year divided by 26 pay periods should be 461.53. If I do 1,200 times 12 months in a year divided by 26 pay periods, it doesn't come out, it's 553. I don't know where they're getting that figure, so I don't know how much they were wage withholding. I can tell you. that it doesn't come out when I do it, so. You ask him, Mr. Garcia, you got paid twice a month or every other week?
I get paid bi-weekly.
Bi-weekly or bi-monthly?
Bi-weekly.
Every other week. So that's 26 pay periods. Yeah.
Right.
So yeah, $1,000 a month times 12 months in a year, obviously 12,000 divided by 26 pay periods comes out to 461.53.
Your Honor, I think it's 565.89 by 26.
Right. And that comes out to $14,713.14.
But wasn't it
And then you
1,000?
divide that by 12, it comes up to $1,226.10.
Oh, that's why it's not coming. I'm doing it the other way around, but I thought it was 1,200 even. It's not. It was 1,002 what?
226.10.
That's where it is.
That's how much they've been taken out.
1,226.
Yeah, it looks like that stopped because it says 542 down here in 2020.
Okay, yeah, I get it now. 565.89. Yeah, I thought it was 1,200 even. Yeah, so we can tell that. Wait, it went down to 542. Hold on.
Yeah, back in 2020.
Mr. Feist, that's because he owed back pay. So that's why it was a little higher in the beginning.
How can he owe back pay if he was?
I don't think
over?
that's correct at all.
Never owed back pay.
If he's
No,
got
in
an 11,300 overage, how could he have owed back pay?
In 2018, Your Honor.
What
When
month
we
in
got-
2018?
You said the amounts are higher in 2018. I'm explaining why the amounts were higher in 2018, Your Honor.
No,
So
no,
he
this
paid-
tracks the court order though. This tracks the court order. The court order we're dealing with, the first one, if he would have had an overage, he would have been showing it in January of 2018. No, Mr. Feist?
Your Honor, I believe Ms.
Well-
Garcia is trying to have calculated into this a court order that was set aside. It was completely set aside. She's trying to suggest that there was back paid owed. It was back paid owed on an order that was wrongfully entered. And that's
So
why
the
Judge
new
Johnson
order,
set it
okay,
aside.
let's take that into account. The new order, which I'm looking at one, April the 4th, 2018, a final decree of divorce. That one doesn't say amended, neutral, anything like that. So is that the one we're going with? April
No.
4th, 2000, there's one after that?
I believe so.
All right, well, let me see if this one has an arrears. And then I gotta check if the new one has an arrears, but it sounds kind of funny that he has an arrears if he's an overpay that much.
There was
they
no
got-
arrears that were factored in or
Yeah.
part of the order or otherwise, Judge. Not at all.
Yeah, I believe that the initial divorce was in 2018, right, Mr. Maycomb? And then you opened it up again, and that's why the child support amounts were higher.
No, the April 2018 was the final decree that was entered by Judge Johnson. There was a prior decree that Ms. Garcia entered by default. Based on our motion to set that aside, Judge Johnson heard that, and her attorney at that point agreed that it should be set aside.
Well, and I have an
So
order
there was
setting it
nothing at that
aside.
point.
I have
Yes.
an order setting it aside, so
Yeah.
we shouldn't even be looking at the other order. The one that's gonna control everything
Correct.
is the new one that's got a date of April.
Yes, and I believe that new one was not tendered to the Attorney General for a long time, and that's why the arrears accumulated. This was
Right,
based-
but that's the Attorney General's mistake, whoever didn't send it. We
Yeah.
all agree that the blueprint that we should be looking at, that should guide our numbers, is the new divorce decree dated April the 4th of 2018. And I'm looking at it right now to see if there's an arrearage. If there's no arrearage, then there's no, yeah. Hold on, because it takes forever to download. Oh my gosh. Okay, child support. It is ordered that Eric Ruben Garcia is obligated to pay and shall pay to Melissa Garcia child support of $1,000, with the first payment being due on March the 1st, 2018.
And that's
There-
what this one has.
Right, and there is no arrears on this one.
Correct.
So we're gonna start March the 1st, 2018. It clearly reflects the obligor's amount. So then we've got to check because he was being wage withheld, whether they included the change starting right there in March. Let me see. So when you take $1,000, you wonder why such a small change, Mr. Feist, from March to April. Is that even correct? The 584, instead of going down, they went up. 584. Oh no, there it is. It went
Going
down.
down.
Yeah, 565. Okay. Yeah, no, that amount seems to still be taking down out the 1,224, 565. I don't think, in other words, the wage withholding remained in place at 1,200. So that's where we should be looking at.
His pay stubs, I believe, Your Honor, they'll show there's a deduction for child support. I don't know that we could use his pay stubs to figure it out, but I don't have them all the way from 2018.
But shouldn't the arrears be, in other words, he was ordered to pay 1,000. The fact that they were taking 1,224, then the difference should only be the $224, right? When you follow it real simply.
Right,
so-
and that's the future pay.
Yeah,
Once they did all this, so they came up with the amount of future pay, and
Which
they
is?
fixed the financial activity report to start the 1,000, and that's why he's shown in future pay.
We already have that amount, right? 11,000.
which is 11,308.
No, $11,068.13.
68. Okay.
So then, I believe if you just calculate from April through the end of September, $717 times 6, that would be the offset of the credit my client would get, and subtract that from the 11,000.
But what Mr. Makam is saying, when you
Oh,
do it that way and you start the 717 from April 2023 to September, that only deals with what I just granted right now, the motion to modify, changing it from 1,000 and I changed it to 1,707. That just takes care of that. What we're trying to figure out is they were taking from his paycheck $224 extra every month when the court order only obligated him to pay 1,000.
Well, isn't that the future pay that they're talking about, the 11,000?
Yes. Yes. So in order for her, she owes him that money because he overpaid. She ended up getting it, so she has it. So in order, she has to repay him 1,068, and then his child support starts at, let's just say she were to give him the cash, $11,068. It puts him whole the way the court order said. He's now he's not owed any money. And then her child support starts April of 2023, $1,707. Granted, he may owe her now because we're doing it retro as of April, but we can fix that. So
Okay.
it's not as simply as just giving her credit for April through September. We got to give him all his money back from 2018. We got to give him $224 every month, which totals to be $11,068. So instead of having her pay him back right now, $11,068, he doesn't pay child support. When you figure out $11,068 times his year or his graduation date, I think he'll come out to where he shouldn't have to pay any more child support. But I mean, that's what we're trying to figure out.
You know what? I believe the family code, I can't find it. I've been trying to look for it, but Mr. Feist might be able to help us with that, is that if there's no agreement, then it just ends early. And whatever, you figure out the pay that she owes and you stop the child support early, and it won't be paid until the child is 18. Is that my correct understanding of the way it's supposed to work?
Yes, it'll basically what'll happen is that $11,068 or $11,068.13, the obligation will stop early, because if he's in future pay towards the end of when the emancipation day or the obligation ends, which is in the system, it'll say,
I think in simple
it'll tell
terms-
them.
Yeah, in simple terms, he pays, let's say starting April, he pays $1,707 and he continues to pay that. and she's going to be getting 1,707 as early as next month. When he turns 18, let's say the Office of the Attorney General, what we're struggling with is what the Family Code states is they give it back to him if there's any money. There's two sections. There's one that says if there's any money left over, if they have it in their coffers, then they give it back to him. But that's not what we have here. She already got the money. So we now have to calculate or when he turns 18, but he's double paying at that point.
But don't you?
He's double paying at that point, because if he keeps paying $1,707, Mr. Harper, from here until the time he turns 18, she's going to get the money, and she already has his 11,308.
But I believe what the Attorney General is saying, they'll terminate it when the child is 16 and a half or 17.
But I think he's already gotten to that point. Don't you think? If you do 11,068 and he's already going to be 15, we're almost at that point anyway. I think it's coming soon, and we need to put it in the order.
There's 3.5 years left.
Does the computer do it for you, Mr. Feist? Input. I thought that whoever is dealing in the financial department has to input in the computer. He is going to get to this point and they have to put it in there. The computer doesn't do it automatically. And at $11,068 is a lot of money. I think we may be at the point to where, he's already.
Well, Your Honor, if you do the 11,068, I know you said, we have to figure out the offset, but it's somewhere in the amount of $4,000. So the actual amount that is that she owes him is in the range of $6,000. And if you do 1,700 times 6 months, that's over $6,000. So it would terminate at 17 and a half, because the end payments would be used to pay him back.
It's like 6.5 months.
That's when he would stop paying early 6.5 months, when the child would be 17 and a half, 17.6, like you said, then he would no longer be obligated to pay child support, right? Because the 1,000
it would stop. The obligation would end. That future pay would take care of the rest of the obligation.
So his obligation would end basically 6.5 months early because of the amount of the payment, 1,707, and he's going to be owed the obliger around 6,000 and something. So it would be for about 6 months that it would end early. It wouldn't be that many months. And I believe, isn't that what the Family Code says?
I'll get to that in a minute. What I'm trying to do is figure out the math. So when you take $11,068 that she owes him, let's just say you divide that by 12 in 1 year. Well, no, I'm backwards. Okay, hold on. Let me look for that section, guys. And because I'm thinking that it applies to this situation. Hold on.
I'm gonna stop sharing for now.
Yes,
I can share again after.
Okay, it says section 154.012 says support paid in excess of support order. I think that's the one we're looking for. It says if an obligor is not in arrears and the obligor's child support obligation has terminated, the obligee shall return to the obligor a child support payment made by the obligor that exceeds the amount of support ordered, okay? Regardless of whether the payment was made before or after their obligation terminated. That we don't have that situation here. It does say an obligor may file a suit to recover a child support payment under subsection A. If the court finds that the obligee failed to return a child support payment under subsection A, the court shall order the obligee to pay to the obligor attorney's fees. Oh, that's something else. Yeah, see, and then this one, 154.014. Payments in, that one was support paid in excess of support order. This one is payments in excess of court ordered amount. Okay, it says, if a child support agency, and I'm assuming we're all going to blame this on the attorney general, we can blame them. Anyway, if a child support agency or local child support registry receives from an obligor who is not in arrears a child support payment in an amount that exceeds the court ordered amount, well, that's what we have here. The agency, to the extent possible, shall give effect to any expressed intent of the obligor. It says, if the obligor does not express an intent on how he wants it paid, the agency shall credit the excess amount to the obligor's future child support obligation and promptly disperse the excess amount to the obligee.
Code
So
section, Your
154.014.
that, and Your Honor, that's what I was driving at with this. I believe the election is Mr. Garcia's, and he can express his intent now. I mean,
Yeah,
which he
the sad thing is, well, I guess if he called enough and tried to tell him, hey, the court order, but we're not going to get into that. We're going back 4 years, but he has to express an intent as to how he wants it dispersed. If he doesn't,
dispersed.
for the past, let's just say for the past from 2018 to now, it says if he has not expressed an intent, it says the agency shall credit the excess amount to the obligor's future child support obligation, which means they need to give him credit now on the future payment. That's the way I'm reading it.
And Your Honor, and that's what he's trying to express.
Yeah,
Is
what he's
that-
trying, what I guess what it sounds like, Mr. Harper, is you give him credit on future, so he doesn't pay child support until that 11,308 is exhausted. But I don't know if you all want to research it. It's not a problem. It's section.
Your Honor, if I can, Your Honor, my read of this is shall give effect to an expressed intent of the obligor. He can express his intent on how he wants that paid now. And that would be the direction of this court order. You know, Mr. Garcia is expressing that he would like this amortized over until the child is emancipated, and 154.014 grants him that election.
There's two sections, Mr. Harper. It's 154.012 and 154.014. But I think the first one deals with
When it's already terminated.
yeah. It's not
One,
terminated.
I believe
It's still, yeah.
154.014 governs, and based on that, it's Mr. Garcia's election.
I don't see any other section dealing with that.
Mr. Garcia,
So then what are my options?
you can have it amortized over the course of this to reduce the 1707 based on the amount of 11,068 that you've overpaid. I had calculated that down to 1437. However, I do recognize that she would be entitled to an offset for the amount between 1707 back to the retro of April 1st and the amount that you continue to overpay during that same April to September timeframe. And then whatever that difference is reduced off of the 11,068 and then amortized over the course of the remaining months till the child's emancipated, which would reduce that 1707 down to whatever that may be, 1,500, 1,450, whatever that amount turns out to be. Judge, I think and again, I'm not privy to their system, but I believe that the system would correct that or self-correct once these amounts are input into their system. To get us an amount today, I think that could be the order of the court, that he's electing to have it amortized in order to reduce that 1707 to what it actually should be.
So Judge, sorry, I just found out some information here. If we go back to April 1st, making it the child support 1708, the future pay will automatically adjust. Okay. Since he was only ordered to pay $1,000 and we're changing it, he's already paid the $1,000. You see what I'm saying? That $708 a month will come off his future pay, which will leave $6,974.99 in future pay.
And then so from that amortized until emancipation puts his support level at what? You said what was the amount that you had calculated, or that it comes to the difference between
if we start, like I was saying, if we start the child support at $1,708 as of the 1st of April of this year, the system automatically uses the future pay to cover that $707 or $708 over the amount he was doing. Okay. So he would say he's been paying $1,000, whatever he's been paying, right? Coming out of his paycheck.
It'll self-correct.
It'll self-correct, right? It'll be using that future pay to pay that. He won't have to pay the $1,700. You see
So
what I'm saying?
in other words, because because it corrects itself, then he doesn't have a child support payment? 'Cause
No,
they're
he
giving
still
him
has it.
credit?
The payment will be
Right.
$1,000, but the
It'll-
700 will be credited towards future pay until it's paid off, right?
See, yeah. So
But by doing it that way?
it'll
are you giving
start,
him-
the
but are you-
payments, his payments will still be 1708 starting, right? If we do it the 1st of April, right? What I'm saying is that the 17, there's no retro in a mod, okay? So it'll automatically, you can only get from, like you said, Judge, from the service time, which was 3/28, the time of first appearance. So using, like Alex says, the 1708 will automatically get adjusted because he's already been paying $1,000, right? It'll come off the future pay. So as of September 1st or whatever it is, after the 6 months is over, it'll be $6,974.99.
That's the future pay that is still owed by my client, right? Okay.
Right.
But
It automatically self-correct. He's still going to pay 1708 whenever the next one's due.
Okay. So how is that balance going to be paid off?
That will come off the end of unless you guys stipulate something different. Hang on, I
No,
still
that
have
doesn't
Alex here.
sound
I'll be
right.
right back.
sorry, I don't know if you got that a little mixed up. It doesn't sound right. Can you have somebody from my financial log on?
Your Honor, but my
I'm,
client,
I'm tracking what he's saying, Judge, and
Does
the
it work
69
that way?
But again, I go back to 154.014, rather than taking it off the back end, just because he's saying that somebody in financial system, the election is Mr. Garcia's. So rather than paying the 1707, if the difference between the 11,068 and what retro credit should be taken off of that, if it comes out to 6974 over the course of the next 46 months, 45 months, whatever it is until the child's emancipated, if that's his election, that would take about $156 off of his child support amount, which is one of the options he has, which would put the support at $1,550 roughly.
Okay, I think what this section says, Mr. Feist or Mr. Harper, is what this section says is if he's not electing, then that's what, and it's shall language, the agency shall. But I guess he is electing. What's throwing me off is what do we do from 2018 to the present? Because we didn't have the benefit of him electing, but you know what? We can't go back. We can't rehash that. He's taking his election now. I mean, unless you want to research that section, but I'm reading it right now. It says the obligor shall give effect to any expressed intent. If he doesn't, then it says the agency shall credit the excess amount to future pay. I mean, future, but anyway.
so if his intent is being made known, my client
Yeah.
does have an offer that's to pay it off over 12 months to give him credit for the $6,974.99. Give him credit in 12 equal payments. And I believe that's around
Where
500.
are you getting the 6,000 from though?
Well, that's going to be what the future pay that he's going to be owed at the end, in the beginning in September. That's what Mr. Feist said. Because
Well, okay, because I think the way you're getting at that is when we calculate from April to
Right.
September, that was, hold on, times 6 months. Oh,
So can I interject here?
yes.
The $6,974.99, our system is set up to, it triggers once it figures out that if there's still future pay there, if there's not enough, if there's more money that's, there that's going to be owed, it'll terminate the obligation. That's the way the system is set up. So that's how that works with the rest of that future pay.
It'll terminate
Right,
6 months before.
Right. As soon as it notices that there's more money in there, then, it'll terminate it at that time.
what my client is really willing to do is give him a reduced child support obligation until that future pay is paid off, and then it goes back up to 1707. Like for 12
See-
months
The issue with that is that causes a problem, because if we still got 4 years left here, and these parties still have the possibility of modifying again after 3 years if one of them wants, because there's a review that comes up every 3 years. If they want to modify again, it's
I
a bigger
think we
problem
have
than
to fix it, because if we do it that way, and I'm not saying you all can't have an offer as long as we're very careful, because what happens is if we factor in that she's going to take less until the date of graduation, if we come back on a motion to modify because he's making more income under not 3 years, but under a substantial change, we're trying to figure out what the credit is now, and then to deal with new numbers when we come back, and to deal with how much of or let's say he doesn't, you can't have an enforcement. Yeah, you can. If you're going to lower the child support to a certain amount, like by $500, and he files a motion to, if she has to file a motion for enforcement because he hasn't paid, then you're dealing with that. So I'm not saying we can't do it. Let's just be, very careful.
and also the future pay, if by chance Mr. Garcia loses his job, that future pay would kick in, right? If he's not getting paid for some reason and we can't withhold it, the
It all
future pay
comes
will.
from the 11,000.
Right.
So how is it going to be collected to offset the future pay? How can you make the order accommodate paying him back?
He has the election. That's what Mr. Makam is saying. He gets to elect.
And we were offering to give him a reduction. I don't know if he's in agreement.
Could I get into a breakout room with Mr. Garcia and I can see exactly what,
Okay,
review
what do you
these
want?
options with
All
him,
right.
and then we can come back and let you know what he wants to do.
All right, we all stipulated to the amount of overage, 11,068.
68.
We all
And
know that
13
we're
cents.
dealing with child support, 13 cents. We're all dealing with child support of $1,707. So let's go with that and see what we can come up with. So Mr. Makam, I'll put you in room 1, and Mr. Garcia, you 2. Mr. Harper, do you want to go to a room with Ms. Garcia just in case?
Sure. Yes, Your Honor.
Okay. We'll put you in room 2. Ms. Garcia, go ahead and join him in room 2. And Mr. Feist, you can go back and forth if you want your co-host.
I
Okay.
can go in my own room, Judge.
Yeah, you can go to your room. Go to your room.